Afternoon. Welcome everyone to this special public sector group webinar on vicarious liability. After last night's football, we have another dream team for you. First, we have Lord Edward Faulks QC. He will speak about vicarious liability and policy. He needs no introduction, which certainly makes my life a lot easier. Look up a leading case and you'll probably find him in it or mentioned somewhere in it. Second, rising star at the bar, Susanna Bennett, will address stage 1 of the test. And last but not least, leading individual in the personal injury bar, Jack Harding, will share his insights on stage 2 of the test. New questions, because existing questions will be dealt with by the speakers. New questions can be dealt with at the end of this seminar, although no extra time. So please put them in the Q&A box at the bottom of your screen. Without further ado, I will pass you on to Lord Edward Faulks.
Thank you very much, Salim. I hope you can hear me. And good afternoon to everybody. The law of vicarious liability has a considerable history, and I'm afraid I've been around long enough to know quite a bit of it. It used to be framed in rather old-fashioned terms, the law of master and servant. We've moved on a bit since then. The law was actually quite straightforward. You were liable for the torts of your employee, provided they were committed during the course of his or her employment. That didn't mean to say there weren't difficult cases when the issue was usually whether or not what the employee did was in the course of his employment, or whether, to use the old-fashioned term, he or she were on a frolic of their own. There were also principles that you couldn't have two employers, stemming, I think, from biblical comments that no man can serve two masters, although we've thought again about that. But axiomatic to the whole approach was that an employer could not be liable for the criminal acts of an employee, because those would, of course, be entirely antithetical to what he or she was employed to do. Now, that was the state of the law until relatively recently. A case called Trotman in the Court of Appeal stated it in pretty clear terms. And then we came to the House of Lords decision in Lister, and that saw a very significant change in the approach of the courts. A warden of a children's home was responsible for abusing these children. It was a boarding home, restricted number of children. And the House of Lords said, notwithstanding that what the warden had done was a criminal act, there could be vicarious liability if there was a sufficiently close connection between the tort and the nature of the employment. And the House of Lords relied on principally some old cases and what the Canadian Supreme Court had said very recently. Now, there followed an avalanche of cases, often involving whether or not there was vicarious liability for various religious organizations who had either been responsible indirectly or directly for sexual abuse. And then came the Christian Brothers case, by which time the Supreme Court was in existence. So Lister was House of Lords, Christian Brothers Supreme Court. Now, I feel rather bitter and twisted about this case because my clients managed to win the case at first instance, win it in the Court of Appeal, but then lose the case in the Supreme Court, where the judges decided that the law was, quote, on the move. In other words, they moved the goalposts, to use a relevant and a timely metaphor. They decided that the old test was no longer appropriate, and they elaborated a rather complex test, including the two-stage analysis, about which you're going to hear considerably more later on. The application of that test has in turn, as you're going to hear, given rise to a considerable number of cases deciding whether or not there was employment and whether or not there was a sufficiently close connection. And inevitably, I think there's going to be some time before we're much clearer, if ever. Now, why? What are the policy reasons behind all this? Now, the trigger may well have been the vulnerability to children or other vulnerable individuals to sexual abuse. But the courts have always made it clear that the law doesn't just apply in relation to sexual abuse, but has much wider application. So the law's more tender approach to those people is understandable. Secondly, I think what constitutes employment has rather changed. We all know about the gig economy and the Uber, Deliveroo and the like. And the old idea of one employment with a contract of employment with strict hours has changed and will continue to change. So the courts have had to be a bit nimble in responding to that. It's interesting, for example, to think that the Police Act in 1964, I think it was, decided that there had to be a statutory provision making the Chief Constable liable for the torts of police officers within their direction. That really wouldn't be necessary now because of the way the courts have approached relationships which are akin to employment. So we now have a policy which is influencing the development of the law. There's been certain retrenchment, and the Barclays Bank case being one which I'm going to hear about, where my clients were able to establish that the old law in relation to the independent contractor consisted. But we have a stage 1 and a stage 2 test. There are lots of difficult issues which are thrown up by this new test. There are a number of factual scenarios which are close to the borderline. I, and I think lots of other members of Chambers and you who are partaking in this video will be aware of them. I can't give you the answers to all the questions, but there are a significant number of questions. And I look forward to hearing your comments and our two speakers as we progress. Thank you very much, Salim.
Thanks very much to Lord Faulks for that very interesting historical discussion of the law of vicarious liability. I'm Susanna Bennett, barrister at 1 Chancery Lane. The aim of our talk today is to go back to basics on the law of vicarious liability. It's a very familiar topic for those of us practicing in civil common law. But what I think we mustn't lose sight of is that it's actually quite an anomalous concept. Generally speaking, in tort law, a party is only liable for their own wrongdoing. What vicarious liability does is it imposes liability because of an innocent party's relationship with another party. As is familiar, there are 2 hurdles to jump over to establish vicarious liability. The first is whether the relationship between the defendant and the tortfeasor is capable of giving rise to vicarious liability. That is the first limb, and I'll be addressing the law on that. The second is whether there's a sufficiently close connection between the relationship and the tort committed, and Jack Harding will be talking about that second limb. Turning to the first limb then, the archetypal relationship for vicarious liability is an employer-employee relationship, but even without a technical employer-employee relationship, courts are happy to accept that sometimes relationships are akin to employment or analogous to employment. The leading case on the first limb is now Various Claimants and Barclays Bank, handed down in April of last year. Lord Phillips in the Christian Brothers case had said that vicarious liability was on the move, and Lady Hale in the Supreme Court in the Barclays case has really brought that movement crashing to a halt. The trend up until this point had been a gradual expansion of vicarious liability. That's now really gone into reverse. And what I'm going to do is I'm going to first talk about a trilogy of important claimant-friendly decisions which preceded Barclays Bank. I'm then going to talk about Barclays Bank and talk about what the law is now like. looking at a few cases decided since then. So this case, which Lord Faulks was talking about, Various Claimants and Christian Brothers, it is a landmark case for both limbs of the vicarious liability test. It's a very important case. The claimants contended that they had suffered sexual abuse from teachers while they were pupils at a residential school for boys. Some of these teachers were brothers, i.e. they were members of a religious order called the Brothers of the Christian Schools. Now, the diocesan bodies managed the schools. They also employed the brothers and all the teachers. The diocesan bodies were vicariously liable, but they appealed against a finding that the institute wasn't also vicariously liable, and that is what this Supreme Court decision was about. What effectively happened, so they basically said that the two parties were liable. Lord Phillips said this at paragraph 35, and these, effectively, he gave 5 policy reasons for allowing vicarious liability, and these have come to be very important in the ensuing case law. So number 1, the employer is more likely to have the means to compensate the victim. Number 2, the tort will have been committed as a result of activity being taken by the employee on behalf of the employer. 3, the employee's activity is likely to be part of the business activity of the employer. 4, the employer, by employing the employee to carry on the activity, will have created the risk of the tort committed. And number 5, the employee will, to a greater or lesser degree, have been under the control of the employer. He then went on to say this at paragraph 47. He said, where the defendant and the tortfeasor are not bound by a contract of employment, but their relationship has the same incidence, that relationship can properly give rise to vicarious liability. So he's effectively saying the same incidence, in other words, those 5 points, which we've just looked at, where they apply, there will be vicarious liability. He then found, or rather the Supreme Court found, with him giving the leading judgment, that in this case, there was a relationship akin to employment between the brother teachers and this religious institute that they were members of. And this is what he noted, that the institute conducted its activities like a corporate body. The brothers undertook teaching because they were directed to do so. The teaching activity was in furtherance of the objective of the institute, and the brothers' code of conduct as teachers was dictated by the institute's rules. So that's a very important case. And we then have Cox Ministry of Justice in 2016, very different facts. A prisoner undertook kitchen work for a very low wage for the prison. He wasn't employed by the prison. He behaved negligently and injured a member of the prison's staff. And effectively what the Supreme Court did is it went back to the Christian Brothers case. It dealt with those 5 policy points, which we've just looked at. And it found that the factors weren't all created equally. So effectively, it found that the first of those factors, the idea that the employer would have more likely to have the means to compensate the victim, that is unlikely to have independent significance in most cases, and therefore shouldn't be focused upon too heavily. Also, the 5th of those factors, namely that the employee will be under the control of the employer, again, is unlikely to have independent significance in most cases. This is because of modern day employment relationships, where often employers don't have that much control over how employees do their work. But the Supreme Court did say that the absence of even a vestigial degree of control would be liable to negative the imposition of vicarious liability. So that's factors 1 and 5, and then it left us with factors 2, 3, and 4. So in other words, activity on behalf of the employer, activity likely to be part of the business activity of the employer, and the creation of the risk. Now, going back to the facts of that case, applying those 3 points, the Supreme Court found very easily that the prisoner's work in the prison was akin to employment. So the prisoner in the prison had a relationship akin to employment. Another very different case, claimant was sexually abused by her foster parents in the 1980s. She sued the local authority, Nottinghamshire County Council, on 2 bases. One was a non-delegable duty, the other was vicarious liability. I'm not going to deal with the non-delegable duty, except to say that the Supreme Court found there wasn't one, but it did find there was vicarious liability. The local authority, pursuant to the Childcare Act 1980, was required to provide accommodation and maintenance to children in its care, which included putting them with foster parents. It then had quite significant power to inspect, to supervise, and to remove children from their foster parents. So it had a lot to do with the kind of foster parent relationship with the children. What the Supreme Court did is it went through the 5 incidents or policy factors that Lord Phillips had given in Christian Brothers. And again, it found that the local authority was vicariously liable for the torts of the foster parents. And just to give you an idea of its reasoning, it noted that foster parents provided care as an integral part of the local authority's organisation of its childcare services. It felt that it was impossible to draw a sharp line between the activity of the local authority who were responsible for the care of the child and that of the foster parents whom they recruited and trained. And it also noted that the local authority's placement of children in their care with foster parents creates a relationship of authority and trust between the foster parents and the children in circumstances where the children were especially vulnerable to abuse. So again, very different facts, but vicarious liability was found. And it's in this context that the Barclays case came to the Supreme Court. The facts are these: claimants were recruited by Barclays. They were required, in order to take up their offers of employment, to pass a medical examination. To do this, they had to go to Dr. Bates's house, who was a doctor. Dr. Bates had a number of different clients. One of them was Barclays, but most of his work wasn't for Barclays. It was for all sorts of different organisations. He received a fee for each report he did, and Barclays sort of directed him by giving him forms and telling him what questions needed to be answered. The claimants alleged they had been sexually assaulted by him during the examinations. Now, the facts are, of course, quite different to the other 3 cases. Dr. Bates is clearly running his own business. He's only answerable to Barclays for specific tasks. But nonetheless, the High Court and Mrs. Justice Nicola Davis, as she then was, gave judgment in favour of the claimants. She went through the 5 factors identified by Lord Phillips. And for all of them, she found in favour of the claimants. So, for example, Dr. Bates, she found, was undertaking activities on behalf of the bank. The medical assessment was an integral part of the business activity of the bank. The bank had created the risk of the tort, etc. And the Court of Appeal effectively upheld her reasoning. And Barclays Bank, represented by Lord Faulks and Katie Ayres, from 1 Chancery Lane, gave judgment and overturned, and the decision of the Court of Appeal was overturned. In a refreshingly short judgment, Lady Hale allowed the bank's appeal. She found that the distinction between a relationship akin to employment and a relationship with an independent contractor still existed. It hadn't been erased by the Christian Brothers case, and that remained the starting point. So where appropriate, there was still that distinction between an independent contractor and someone who was akin to an employee. She was also critical of how focused the previous decisions had been on going through those 5 policy points given by Lord Phillips. And this is what she said. She said there appears to have been a tendency to align the policy reasons for the doctrine of the employer's liability for the acts of his employee with the principles which should guide the development of that liability into relationships which are not employment. And she then went on to say, I do not believe that by his reference to those incidents, Lord Phillips was saying that they were the only criteria by which to judge the question. And two reasons, one of which is Lord Phillips actually didn't himself base his decision on those 5 policy points. He looked at the facts of the case. And this is the crucial paragraph. The question is whether the tortfeasor is carrying on business on his own account or whether he's in a relationship akin to employment. And it's only in doubtful cases that you should consider the 5 incidents in terms of identifying a relationship which is sufficiently analogous to employment to make it fair, just and reasonable to impose vicarious liability. She then found on the facts very easily, without going to those 5 points, that Dr. Bates was an independent contractor. I should say none of the other decisions, such as the arms case, were criticised in terms of their outcome. They were only criticised in terms of, I mean, not directly criticised, but implicitly, in terms of focusing too much on those 5 policy points. Now, there have been a number of decisions on vicarious liability since the Barclays Bank case was handed down. I've selected 3 of them, which I think are very different and which I think give us a good idea of where we are now. The first of them is SKX and Manchester City Council. This is it's a bit different from the arms case. The local authority placed the claimant in a children's home in the 1980s. The children's home was run by a company, and the claimant was sexually abused by a senior employee of the company. Now, the company was carrying on its own independent business. The defendant was just one of its clients. Applying Barclays Bank, as I'm sure you can guess, the company was found to be in a classic client-independent contractual relationship with the defendant. So in terms of the relationship between the tortfeasor and the defendant, it certainly wasn't akin to employment. And the 5 factors didn't need to be considered. It was very clear that there was no vicarious liability. Very different case. This is just a county court decision, but it's a very interesting one, and it's in the healthcare context, so different to the ones we've looked at. Claimant was treated at Fountain Dental Centre practice, which was owned by the defendant. The defendant provided this care pursuant to contracts with the local health board, by which the defendant provided dental services to the public in exchange for payment by the local health board. The defendant engaged different dentists to provide care to the claimant. All of those dentists were self-employed and independently insured. So in a tax perspective, they were running their own business, these dentists. The money from the local health board was then apportioned between the practice, so this sort of firm, I guess, and the individual dentists. And the claimant, when she went for appointments, would be assigned to different dentists by the practice. In this case, the defendant who owned the dental practice was found to be vicariously liable for any negligent treatment. The judge, His Honour Judge Harrison, found it was significant that the dentists were given targets of how much dental treatment they needed to provide each year, and the practice was the provider of dental care and had obligations to ensure that dental services met standards. And he did deal with the 5 factors, and he kind of addresses them broadly in this paragraph. The work undertaken was on behalf of the practice. The defendant's business was the provision of dental care, and that is what the associates provided. The business received a direct financial benefit from the work they undertook. They afforded the opportunity. There was sufficient control to establish vicarious liability, and the fact that associates managed their own tax affairs and or made their own insurance arrangements does not displace that conclusion. So that's an interesting one in terms of showing, even if technically you could say they are running their own businesses, given that what they're doing is providing dental care in this dental surgery with a lot of close connection there, they were found to be in a relationship akin to employment. Finally, JXJ and Province of Great Britain of the Institute of Brothers of the Christian Schools. This is quite a complex case. The judgment is about 70 pages long, so you'll have to take the summary from me. The claimants was trying to argue that the religious institute, which was the same one as in the Christian Brothers case, was vicariously liable for a tortfeasor who was employed by the school, so not employed by the religious institute, and the tortfeasor themselves was not a member of the institute. So whereas in the Christian Brothers case, the tortfeasors were all brothers, so members of this religious order. In this case, the only real argument was that the institute had some control over the running of the school. They basically had a lot of influence on the headmaster, and the court found they did have de facto control over the operation and organisation of the school. And so the claimants were trying to argue that this meant there was a relationship akin to employment between the tortfeasor, who was a member of staff, I don't think actually a teacher, and the religious order. But Mr. Justice Chamberlain in the High Court found that there was no vicarious liability. He found that the institute was pursuing one objective and doing so through these Christian Brothers. But in terms of other staff, they were employed by the school, but they just weren't closely connected enough with the institute itself. So those are the three cases. Now, to summarise, the guiding principles, I think, are as follows. Following the case of Barclays, we have to ask the question whether the tortfeasor was clearly an independent contractor or whether he or she was clearly in a quasi-employment relationship with the defendant. And so I think you should ask yourself, was the tortfeasor running their own independent business? Alternatively, were they entirely engaged in pursuing the defendant's aims like an employee is? And if there's a clear answer to that question, you don't need to go any further or get into the details of paragraph 35 of the Christian Brothers case. That's the end of the analysis, which is great. But otherwise, you turn to the 5 policy factors and see if they point in a particular direction. Just a few hints and tips. Stand back from the facts, take a common sense approach, look at it broadly. Does the tortfeasor look like an independent contractor, or do they look more like an employee? The development of the law in this area is going to be incremental and pragmatic. And if you are dealing with a case which is on similar facts to one of the other previously decided cases, that is going to be a very good indicator. So look back at the previous case law and see if you can spot any patterns. Remember also that what you're looking at is the relationship between the tortfeasor and the defendant, not, for example, the tortfeasor's employer or anything like that. There needs to be this relationship between the tortfeasor and the defendant. Also think about how integral the tortfeasor's work is to the defendant's operations. So, for example, in the Breakingbury case, the dentist's work was obviously entirely central to what the dental practice was doing. And I think that was probably a factor in terms of finding vicarious liability. Whereas in Barclays Bank case, clearly a medical examination is not absolutely central to what Barclays Bank was doing. So that's the end of my talk on Limb 1, and I hope it's been interesting and helpful. And before I finish, I've seen a few questions have been submitted, and I'm going to look at a couple of them. They're very good questions. So one of them was, who will be the employer for vicarious liability purposes when a subcontracted operator of plant assaulted an employee of the primary contractor? And I think the answer to that is it really depends on the facts. So if the if the subcontracted operator is very integrated into the primary contractor's work, and if they're only really doing work for the primary contractor, then I think that would point in the direction of them being akin to an employee. But if this operator is doing work for all sorts of different contractors and really not following anyone's rules, I mean, clearly they weren't following rules when they attacked someone, but following their own rules in terms of how they worked, that is going to be significant. So unfortunately, my answer to that is it really depends. Is there a risk of vicarious liability if someone's seconded to another company, that company will then be vicariously liable? I think yes, definitely, because it depends how they're operating, but if they're effectively working for the company they've been seconded to, that seems to me just the sort of situation where you look a lot like an employee to a judge. Another question, in healthcare settings, when a surgeon attends and practices with practicing privileges but has their own indemnity and is self-employed, will there be vicarious liability? I mean, of course it depends. If they're doing work exclusively for a particular healthcare provider, and I mean, if it's analogous to the dentist case we were looking at, Breakingbury and Croad, then I think you are probably looking at vicarious liability. The fact the surgeon has their own indemnity and is self-employed in a tax sort of sense is not going to be the only factor. Of course, that's a sort of a factor pointing in the direction of being an independent contractor, but it's only one factor. And it looks as though in the healthcare setting, there's more likely to be vicarious liability. So that's all the questions I think I've been asked so far. But thanks very much. And I'm now going to hand over to Jack. Jack, are you there?
I am here, thank you. I'm just going to bring up the PowerPoint, give me a moment. Right, hopefully everybody can see the PowerPoint on the screen. Good afternoon, everybody. Just picking up on one of the final questions that Susanna dealt with at the end there, which is the question of whether an employer can be vicariously liable for a loaned employee. I did notice, as part of my reading in for this seminar, there was a recent decision of just May this year in a case called NatWest Markets and Bilter, which considered, at least tangentially, that very point. So I don't have a note who asked that question, but whoever it was might want to have a look at a very recent judgment on the decision. First of all, can I just say I hope everyone's recovered from last night. I know I found it quite stressful. Hopefully this seminar is going to provide some breathing space on a Thursday lunchtime. I'm talking about stage 2 of the test, and the title for this entire seminar is Hunting the Chimaera. Hunting the what, you might well ask? Well, that's a comment that comes from Lord Dyson in the case of Mohammed and Morrisons, that is to search for certainty and precision in vicarious liability is to undertake a quest for a chimera. You may or may not, the chimera is the mythical beast from Greek mythology with the head of a lion, a goat sticking out of its back, and a snake's tail. So in other words, a curious and not altogether satisfactory mishmash of parts, and one might say the same for the way that vicarious liability has developed over the years. As Lord Faulks elegantly explained at the beginning of the seminar, the strong policy reasons that underpin the imposition of vicarious liability have not always translated particularly well into a consistent or coherent set of identifiable and manageable principles. And indeed, in a case called Heasman's and Clarity Cleaning, back in the 80s, Lord Justice Purchase said, in one sense, the question of where the law should draw the line is an almost arbitrary one, and wherever the line is drawn, there are bound to be anomalous cases lying close to and on either side of the line. And I think we find that particularly under stage 2 and the close connection test. It's an area of the law which, as Susanna indicated, has developed incrementally and with different strands emerging almost like sort of capillaries on a leaf, which do make it difficult to grasp precisely what the reasoning is at times. I think any discussion of stage 2 has to start with Mohammed and Morrisons. You'll recall that Mohammed was the case in which the motorist went into the petrol station sales kiosk late at night and asked if some documents could be printed. The attendant refused the request. He ordered the motorist to leave using racist language. He then followed him to the forecourt, ordered him to get in his car and not to return. The motorist refused, and he was then seriously assaulted. You'll see that Lord Toulson, giving the lead judgment in the Supreme Court in Mohammed, held that it was Mr. Khan's job to attend to customers and respond to their inquiries, and his conduct in answering the request in a foul-mouthed way and ordering him to leave was inexcusable, but within the field of activities assigned to him. And then the next passage below is one that has taken on some importance. When Mr. Khan followed the claimant back to his car and opened the front passage door, he again told the claimant in threatening words never to come back. This was not something personal between them. It was an order to keep away from his employer's premises, which he reinforced by violence. And in giving such an order, he was purporting to act about his employer's business. It was a gross abuse of his position, but it was in connection with the business in which he was employed to serve. His customers entrust him with that position, and it's just that, as between them and the claimant, they should be held responsible for the employee's abuse of it. Now, there were other aspects of the decision of Lord Toulson in which he referred to the entire event being a seamless one, and the close connection in time and space between the assault and what had happened in the petrol station, that have at least created a risk of being misinterpreted. The decision in the Supreme Court in Mohammed did come under a bit of criticism elsewhere in the world. In a decision of the High Court of Australia, in a case called Prince Alfred College in ADC, this was a sex abuse case. You see there what the majority decision in the High Court had to say about Mohammed. The essential point that they were making is that they were expressing concern that the language used by Lord Toulson might be interpreted as an invitation to disregard what these cases are really all about, which is to say, the imposition of liability not on the tortfeasor, but on his or her employer. And therefore, as the quote on the screen suggests, the need always to have regard to the course of employment as setting the outer limits of the doctrine, whatever else might be relevant by way of breaking down that analysis. And so it's with that in mind that one comes on to the most recent authority of Various Claimants and Morrisons. And I would pause to note that this might well be the greatest act of litigation redemption in history for a company, Morrisons, here to return to the Supreme Court in a matter of just a few years on the very same issue and to secure a very, by any means, defendant-friendly judgment. It seems to be quite some achievement. You may or may not be familiar with the facts of Various Claimants and Morrisons. They are set out on the screen. So Skelton, an employee of Morrisons, was a senior auditor in the auditing team. In July 2013, he was subject to disciplinary proceedings for minor misconduct, about which he was very unhappy and harboured an irrational grudge against Morrisons for subjecting him to those proceedings. He was, as part of his job as auditor, given access to the payroll data relating to the whole of the Morrisons workforce, about 126,000 people. And what he did was, as part of his role as auditor, surreptitiously copied the data from his work laptop onto his own USB stick. He used the name and date of birth of a fellow employee in an attempt to cover his tracks and frame that employee. And then on a different date, at his own home, he uploaded a file from that USB stick containing almost 100,000 of the names and details of the employees to a publicly accessible website. And he made the disclosure, as I say, at home on his phone and using the false email account. Now, the decision of the first instance judge, which, and I've included a quote from it on screen, was approved in terms by the Court of Appeal decision, which along these lines. And what the judge says was, I reject Ms. Proop's argument for the defendant that the disclosure of the web on the web of the payroll data was disconnected by time, place and nature from Skelton's employment. I find rather, as Mr. Barnes for the claimant submitted, that there was an unbroken thread that linked his work to the disclosure. What happened was a seamless and continuous sequence of events. These actions were all part of a plan, and as the research and careful attempts to hide his tracks indicate, this was not a sequence of random events, but an unbroken chain beginning even before and including the first unlawful act of downloading the data onto the USB stick. Now, pausing there, if you didn't know this was a case about vicarious liability, you might think that those were comments addressing matters of causation or remoteness, or, for example, foreseeability of damage. Those are all concepts familiar to the civil lawyer, but they are not, or at least hadn't been, prior to the interpretation of the Morrisons and Mohammed case, not conceptually relevant at the stage 2 analysis and vicarious liability. What the Supreme Court was concerned to do was to reimpose what I've called the Dubai aluminium orthodoxy, and it was the same concern that was expressed by the High Court of Australia in the Prince Alfred case. What Lord Nichols had said in Dubai is that perhaps the best general answer is that the wrongful conduct must be so closely connected with the acts of the partner or employee was authorised to do that for the purposes of the liability of the firm or the employer, the wrongful conduct may be fairly and properly regarded, and this is the important part, as done by the partner while acting in the ordinary course of the firm's business or the employee's employment. And so Lord Nichols, and as the High Court of Australia emphasised, was that however you analyse these cases, the outer limits must always be the ordinary course of the firm's business or employment, because it is the employer whom you are seeking to render liable through the device of vicarious liability, not simply the tortfeasor. And that being the case, the Supreme Court made what it seems to me are 2 key observations. Well, that's 3 key observations. The first is that the mere fact that the tort occurs within the time frame, or at least starts within the time frame of the employment and the workspace, isn't necessarily an answer. There's a fallacy inherent in the court of appeal approach that just because the acts fell within the broad range of activities, that they somehow had to be regarded as a natural outgrowth, whatever the personal motive behind them. And so in Various Claimants and Morrisons, you'll see the court there referred to an early decision called Kuragang, which Lord Wilberforce rejected the argument that just because the employee is doing acts of the same kind as those it's within his authority to do, the employer is liable and is not entitled to show that his employee had no authority to do them. And then I've underlined the argument, the point that even while performing acts of the class which he was authorised or implied to do, he may so clearly depart from the scope of his employment that his master will not be liable for his wrongful acts. And with that in mind, the Supreme Court made 2 important observations about the decision in Mohammed. The first is that the focus is on the scope course of employment and not on causation in time or space. And so going back to the facts of Mohammed, what the Supreme Court in Various Claimants and Morrisons emphasised is you see there that although Lord Toulson had referred to an unbroken sequence of events and a seamless episode, that was not directed to causation in temporal or spatial terms, but actually towards the capacity in which Mr. Khan, the petrol pump attendant, was acting when those events took place. And the important point there being that when he committed the assault against the motorist, he was purporting to act about his employer's business. In other words, he was still clothed in the capacity of Morrison's employee. So it wasn't important, or it wasn't decisive that what had happened only took a short period of time, although what had happened was still on the petrol station forecourt. What was important is that Mr. Khan, in assaulting the motorist, was doing so whilst purporting to act about Morrison's business, and in that sense enforcing what in his mind was a sense of control and authority over motorists at the petrol station. The second point that emerges from Various Claimant and Mohammed is that it really does matter whether or not it was personal. In Mohammed and Morrisons, Lord Toulson had made the statement that Mr. Khan's motive was irrelevant, and that line had been picked up upon in a number of subsequent cases, including by the High Court and the Court of Appeal in the Various Claimants and Morrisons case, and had been interpreted as meaning that you simply don't look at the reasons why the tort fees is acting as they are. Now, the Supreme Court in Morrisons made it clear that the purpose of the tort is highly relevant. It may not be relevant what the specific subjective reasons behind it are. So, for example, it doesn't matter if the tortfeasor is motivated by, I don't know, sexism rather than racism, but it will matter if those personal motivating factors have taken the acts beyond the scope of the employment. And so, again, you see in the passage on the screen there, the question was whether Mr. Khan was acting, albeit wrongly, on his employer's business or was acting for personal reasons. And that was regarded by the Supreme Court as being of plain and indeed central importance. And so the way that the Supreme Court resolved the facts of Mohammed was as follows: that it is abundantly clear that Skelton was not engaged in furthering his employer's business when he committed the wrongdoing. On the contrary, he was pursuing a personal vendetta, seeking vengeance for the disciplinary proceedings some months earlier. In those circumstances, his wrongful conduct was not so closely connected with acts which he was authorised to do that for the purposes of Morrison's liability, it can be fairly and properly regarded by him as done whilst acting in the course of his employment. So really, we come back full circle to the age-old distinction between acting in furtherance of the employer's business or being on a frolic of one's own. And prior to the seminar today, we received a question, I think from Peter Wake from Wakeman's, who I think is on the line, so hello Peter, about how all of this sits with vicarious liability for harassment. And you'll recall that back in 2006, the House of Lords, in a case called Madrowski, had decided that there was nothing inherent in the scheme of the Protection from Harassment Act 97 to exclude vicarious liability. What the House of Lords didn't do in that case was to specifically address, at least in any real detail, the stage 2 tests on the facts of Madrowski. And in my view, it's not difficult to think of cases which on the facts lie either side of the personal versus furtherance of the employer's business line in the context of harassment. And the next case I want to talk to you about is an old one, but I think it's a really good example of a case where a clearly personal act didn't lead to the imposition of vicarious liability, even though it was committed squarely within the time and space of the work. And that case is Irving and the Post Office from 1987. It was actually a claim, and the reason why I mentioned the Protection from Harassment Act, it was a claim that was made under the Race Relations Act for race discrimination. It was cited with approval by the Court of Appeal in Madrowski. So it is, I think, a good example of where the line might be drawn. And so in Irving and the Post Office, the claimants, both Jamaican, lived next door to Mr. Edwards, and they had a major falling out over some time over that age-old dispute at parking. Mr. Edwards was a local postman and he worked in the sorting office, and this took place at Christmas time. He saw, as part of his duties in the office, an envelope containing a Christmas card that was sent to the claimants, and he wrote a racial slur and drew an offensive cartoon on the back of the envelope and then ensured that it was posted to his neighbours. And they, not surprisingly, sued for racial discrimination. Now, what the claimant's case in Irving was as follows: that they sought to argue, well, this clearly fell squarely within his job of writing on envelopes, and therefore it's entirely unrealistic to say that what he did was outside the course of his employment. You can see on the screen the argument was that the job upon which he was engaged was sorting mail, and writing on the envelope was within the scope of that employment. The time he spent was so short and such a minor interruption in the overall legitimate process of sorting the mail that it should be treated as part of one transaction, and that to differentiate it from other actions that preceded and followed it would be unrealistic. And so the argument there is that you can't simply dissect down the process of writing on envelopes into constituent parts and say, well, as he picked up the envelope for the first time, he was acting in the course of his employment, but when he put pen to paper and wrote the slur, that took him beyond the course of his employment. And the Court of Appeal unanimously dismissed the claim. And what they said was this, that what he did was an act which can't be regarded as merely an unauthorised way of performing the duties for which he was employed. Out of personal malevolence, he wrote the offensive message. That was not the performance of any duty for which he was employed. His employment provided the opportunity for his misconduct, but it was simply a piece of spite on the spur of the moment. He was, of course, authorised to write upon the envelopes, but what he wrote, and I would say importantly, the purpose of what he wrote, had no connection with the performance of his duties. Now, it seems to me that is a good example of the orthodoxy that various claimants and Morrisons sought to reassert, which is to say that the purpose of the act will assume increasing importance. In this case, it was clearly an act of personal revenge related to a parking dispute that had nothing to do with the post office or the employment. And whilst the employment at the sorting office gave him this opportunity to act as he did, beyond that, there was no connection to what the postman's actual job was. So that, I think, is an example, as I say, of the principles that emerge from various claimants in action. I want to discuss now briefly, by way of detour, the case of Brinks Global and Ibrox. There have, over the years, been a number of cases involving theft of goods, and you might think that theft is a primary example of acting for personal reasons. Obviously, it's your personal gain, and certainly not in any way purporting to act about the employer's business. And in Brinks Global and Ibrox, on the face of it, you have a situation where what happened was motivated entirely by dishonest personal belief rather than anything else. Brinks, the well-known security company, entered into a contract with a bank to carry 627 silver bars, and they were stored in containers on wooden pallets. Now, the defendant was a firm of insect fumigation contractors, and they were instructed to disinfect the pallets. Now, the one important point is, for that purpose, they did have access to what would otherwise have been a secure set of containers. But beyond that, they had no role in looking after the silver, in ensuring its security. They simply had access to it for the purposes of fumigating the pallets upon which the silver was stored. Anyway, two of the defendant's employees failed to fumigate the container. Instead, they stole 15 bars of silver, and then they resealed it, and the theft was discovered 3 days later, and the silver was never recovered. The Court of Appeal, in particularly forceful terms, had no difficulty whatsoever finding that the employer was vicariously liable for what had happened. But what strikes me most about Brinks Global and Ibrox is it came relatively quickly off the back of the Lister and Hesley Hall case that Lord Faulks referred to at the outset. And as we know from various claimants and Morrisons, the sexual abuse cases have developed a strand of reasoning and principles all of their own. And yet we see in Brinks Global and Ibrox references to the reasoning in Lister and Hesley Hall justifying the imposition of vicarious liability in the theft cases. So we see references, for example, in this passage to the concept of risks being reasonably incidental to what the tortfeasor was employed to do. But then in the second paragraph, the argument that has succeeded in the previous cases of sexual assault was that the tortfeasor's employment simply provided him with the opportunity to assault the boys in his care, acts which were plainly not part of what he was employed to do. And in Lister and Hesley Hall, Swinton Thomas relied on Heasman's authority for that principle. However, that argument was decisively rejected by the House of Lords in favour of a more flexible approach. And then this passage, the theft of office equipment which a cleaner is employed to clean is now likely to be regarded as a wrong committed in the course of employment, and it's doubtful whether other forms of misuse of the same equipment are to be viewed in a different light. So query whether or not theft cases are following a line similar to the sexual abuse cases, in which case do we have a third strand of vicarious liability cases, or is this an example of a case which applied the reasoning in the sexual abuse cases, but which now, following various claimants, might be decided differently because of the recognition that sexual abuse cases have a set of principles and reasoning which are unique to the facts of those particular cases. Before I bring us right up to date with the post various claimants and Morrison's decision, I just want to speak very briefly about one final case. I haven't got a slide for it, but just to again illustrate the distinction between personally motivated acts and acting in the course of the employment. And that's the case you'll probably be aware of, which is Gravel and Carroll, the rugby scrum case, in which one of the rugby players thumped another in the melee following a scrum. And in that case, the Court of Appeal held that it wasn't a case of private retaliation at all, that it was a punch thrown in the scrum. The melee and the scrum were, in a real sense, part of the game. Obviously, the punch shouldn't have been thrown and was potentially even criminal, but it was an incident of the game and thus the first defendant's employment. And it seems to me that's a more justifiable decision falling on the other side of the line, namely an act carried out in furtherance of the business of playing the game, given the rough and tumble of the rugby scrum and the melee, and doesn't go so far as to constitute a frolic of the employee's own. Bringing us right up to date, Shell and Tarmac Cement. This was a decision on appeal in the High Court all about practical jokes. It starts with a particularly grumpy comment from the High Court judge to this effect, that the practical joke must be the lowest form of humour, it's seldom funny, there's often a form of bullying, it has the capacity to go seriously wrong. And then he quotes Mark Twain saying that when grown-up persons indulge in practical jokes, they've lived narrow, obscure and ignorant lives. At full manhood, they still retain and cherish a job lot of leftover standards and ideals that would have been discarded with their boyhood if they had then moved out into the real world and broader life. I'm not sure I entirely agree with that. Sometimes they can be funny, but certainly on the facts of this case, it went seriously wrong. The claimant was employed, as you see, as a site fitter, contracted to the defendant. The claimant had complained over a period of months of tensions between himself and the defendant's employees because there was concern about the defendant's employees losing their job to outside contractors. So he said there was an unfortunate atmosphere in the workplace that made him feel uncomfortable, but he had never felt physically threatened by violence. The defendant's employee hit 2 pellet targets with a hammer as a practical joke that were placed against some drums, and it caused a loud explosion close to the claimant that seriously damaged his hearing. The defendant defended the case purely on the principle of vicarious liability. It didn't, in the end, call any of its own witness evidence at all. But at first instance, nonetheless, His Honour Judge Rawlings dismissed the claim, and I've set out there, in summary, his reasons for doing so. I'm not going to read all of them, but the most important, it seems to me, are the fact that the work merely provided the employee with an opportunity to carry out the prank that he played, rather than in any sense being within the field of activities that had been assigned to him. On appeal to the High Court, the claimant sought to, you might say, re-argue those factual findings. In particular, and you'll see from the second bullet point, there was the kernel of the argument was that the transition from working in the course of the employment to the practical joke that caused the explosion was a seamless episode and should have been understood as something within the cause of the employment, and that it was the employment that created the opportunity for the incident, bringing working men together with no apparent supervision, training or disciplinary policy. Now, the decision at first instance in front of His Honour Judge Rawlings had been decided before the Supreme Court in Various Claimants and Morrisons. By the time it reached the High Court, various claimants have been decided. And you'll see here that the High Court was fortified in dismissing the appeal by reference to the Supreme Court decision. The judge noted that it's clear following various claimants that the temporal connection is less significant in itself, with more weight to be attached to the capacity and purported basis upon which the perpetrator acts. And then the judge went on to say that he rejected the suggestion that Judge Rawlings had failed to give adequate consideration to the matters argued, and that the argument that the transition from working in the course of employment to causing the explosion was seamless and should be readily understood as something within the course of the employment appears to be essentially a reference to the temporal connection, which the claimant conceded is of even less significance since the decision of the Supreme Court. So again, I mean, there have been over the years a string of practical joke cases, and I think maybe one or two out of the many cases that have come before the court have ever resulted in the imposition of vicarious liability. They're a good example of an act which will rarely be anything other than personal or a frolic in the classic sense of that word. But it seems to me that following Various Claimants and Morrisons, it's even more difficult for the claimant to succeed because of the renewed focus upon capacity and personal motivation, and the diminishing emphasis upon the causal connection between the fact that it happened at work leading to the ultimate assault. So that brings me right up to date. I just want to finish with a few words on where we go from here. And I've posed the question as to whether vicarious liability is still on the move or is finally slowing down and possibly going full circle. My view is that it's unquestionably still on the move when one's considering stage one, as I think Susanna's exposition of the cases readily demonstrates. When it comes to stage two, I think there's a strong argument that it is slowing down. And the reason I say that is that by re-emphasising the importance of the course of employment, the Supreme Court really does take us full circle right back to 100 years or so, when that orthodox test was first stated. There is this curious, I'll leave it at that, exception for sex abuse cases. There is a distinct body of case law that is emerging in relation to them. Why are they treated differently? I have argued in an article I wrote last year that perhaps they shouldn't be, and that there is a coherent narrative that draws the two strands of case law together. But that is a seminar in its own right. I'll just leave you with this comment that my understanding is that there is a decision from last year, the case of DSN and Blackpool Football Club. I understand from speaking to solicitors for the defendant yesterday that is going to the Court of Appeal in just 2 weeks' time. And it's going to be an important case, it seems to me, in the context of sexual abuse on both stage one and stage two. So that's a case to keep your eye on. But I think I have finished my exposition of stage two, and I'm going to hand you back to Salim to see whether any questions have arisen during the course of the seminar. So Salim, over to you.
Thank you, Jack. How fitting that you should cover practical jokes at work. But thank you to all the speakers for that comprehensive analysis. We are into extra time now, but yes, I do see a couple of brief questions in the Q&A box at the bottom of the screen. So if I could ask the speakers to have a look at them, please. First one from an anonymous attendee. In the light of...
I'll take that one, Salim. The question is, in light of Mohammed, do you think Irving would be decided differently today? No, I don't. And I think the reason for that is Various Claimants and Morrisons. And I think, as I explained, that Irving is a quintessential example of the importance of focusing on the personal nature of the act, as distinct from the fact that the employment gave the opportunity to commit the act. And therefore, no, I think that Irving was rightly decided at the time and would be decided in the same way again.
Thank you very much. And how about the second question on stage two?
Well, I don't. On a stage 2 analysis, I mean, the direction of travel of the case law, it seems to me, is very much towards an increasing finding of vicarious liability for sexual abuse in any case where there is regular contact with children in a sort of supervisory or care capacity. So obviously it would depend upon the facts of the case. Sorry, I should have read the question. How do you see stage 2 analysis running in the case of sexual abuse of a child by, say, a local authority social worker? Again, it is going to depend upon the facts of the case, but because of the different strand of case law on sexual abuse cases, the mere fact that it is obviously a personal act is not determinative. And so, you know, if the social worker has regular access to the child, for example, going into its house, sitting with the child on their own, away from parents, talking to it, then yes, potentially, but it would require a close factual analysis.
Well, there is one more question that's just popped up. I think we'll take this final question.
Someone else want to have a go?
I think it's a stage 2 question. It's about an employee.
So the question is, if an employee makes unwanted sexual advances at work towards other employees or members of the public, the employee being a security guard, is the employer liable, or could the employer escape liability? It's interesting. There was a recent decision involving sexual abuse of one adult towards another, and forgive me, I can't remember the name of it. The defendant was a music company, and the High Court judge did say that the mere fact that the victim is an adult rather than a child will not necessarily make any difference to the principles to be applied. However, if you're talking about a situation where there's no element of vulnerability, there's no element of the employees being alone in a I don't know, vulnerable state, then mere sexual advances, you know, during office hours in the corridor or something like that, might well not fulfill the definition of being so closely connected. They might well be regarded on the facts as a personal act rather than something that is closely connected to the particular nature of the employment. I mean, in Lister, obviously, the quintessential example, what was important was the fact that the housemaster had regular intimate access to the children in a sort of dormitory style setting, which would be completely different from a security guard. But again, I don't think it's possible to give a definitive answer without knowing all the probably quite important detailed factual nuances.
Well, I think that's the virtual whistle. Thank you again to all the speakers and to all of you for attending. Please check our Chamber's website for details both of the speakers and of future webinars. I wish you a very good afternoon. Thank you.